attorneys, both plaintiffs and defense, are still just as busy as ever. Second kind of accidents, personal injury cases, are usually premises liability. And that's where somebody trips or slips and falls or is injured by some product on a premises that is considered to be dangerous or that was not properly maintained. An owner of premises or an occupier of premises has a duty of reasonable care to maintain the premises in reasonably safe condition for foreseeable users. In the old days, if you were on a hotel, you had to be a guest or a business invitee or somebody like that to be able to sue them. Not anymore, because hotels are open to the public, and they just, yeah, forget that, that's nonsense. If they're there and they're a member of the public, we know that hotels invite members of the public to come, and if they get hurt because the hotel did not have safe premises, for example, we've got a case now where the hotel, Neighbor Island Hotel, had an open lobby area to the elements, and so a lot of times you get wind-driven rain. Wind-driven rain in Hawaii are fact of life. Have it all the time. And on that particular occasion, they had warning cones up over on one side of the elevators, but not on the other. So the guests came in on the side with no warning cones. They didn't see the water because it was just clear liquid on the tile surface. Slipped, had a really bad ankle injury. Unlucky. I mean, normally they just get bumps and bruises, but sometimes you get people who are really badly hurt, and this one did. And in this case, the liability of the hotel is because they knew there were wet conditions. That's why I had the cones on the other side of the elevator bay. Unfortunately for the hotel, they didn't have cones on the side that the person came in on. So they're probably going to be on the hook. Had another case where the lady was walking back from the swimming pool to her room, and on the walkway, she slipped and fell, had a really bad wrist fracture, and doesn't have much use of that hand anymore because the wrist fracture was so bad. And the hotel said, well, but we had a safe surface, we had non-slip, and we had all that good stuff. And unfortunately for the hotel, one of the hotel workers came up right after the accident and said, you know, this happens right in this spot all the time. They put a lot of money into trying to make this surface safe, but it's right by the pool, and there's kids, and there's suntan lotion, and there's spilled stuff. And so the arbitrator in that case, who was a former county attorney for 20-something years, sorry, you knew it was dangerous, and you didn't put up warning signs. If they had put up warning signs, they probably would have been okay. We actually had an expert go out to him. He said, you know, the surface in normal conditions is safe. You know, it's a non-slip surface. It's fine. But unfortunately, because it's right next to the pool area, and they know that people are using sunscreen and coconut oil and spilling stuff and all that, they need to put up warnings. Another Hawaii case, Gump versus Walmart. It was a premises case where the person slipped and fell and got hurt in Walmart. And Walmart had a McDonald's inside Walmart. And usually in premises cases, the rule is that the owner or the occupier of the premises has to be aware of the dangerous condition. They need to know there's a spill, they need to know there's some dangerous condition or a pothole or something like that before they're liable. But in the Gump versus Walmart case, the Hawaii Supreme Court said, if the premises owner chooses a mode of operation that creates a foreseeable risk, they can be responsible even if they didn't know about the particular condition that happened at that time. And their reasoning was basically, Walmart, by putting McDonald's in there, knows that there's a lot of kids, there's a lot of old people, people spill stuff. And if they don't police it adequately and have warning signs out there and somebody falls and gets hurt, the Supreme Court of Hawaii decided it was more socially responsible and legally correct to place the responsibility on Walmart, because by having Walmarts inside without adequate maintenance, supervision, warnings, etc., they created an additional risk that was a mode of operation they chose. They could insure against it, and so the Supremes put that responsibility on them. Since that time, many slip and fall victims' attorneys have said, oh, mode of operation, now we don't have to prove that the premises owner knew about the dangerous condition anymore. So the Supremes have come out with a more recent decision that says, well, we're really talking more about the big box guys who have things in there. For example, Costco, you see the people out with the samples, eats and drinks all the time. If that stuff spills and somebody slips on it, Costco's going to get hit because that's their mode of operation. On the other hand, if you've got somebody who's got a plant nursery and it rains and somebody walks through the plant nursery looking for plants and they slip and fall, they may not be held responsible unless they had noticed that that area was dangerous or slippery. And that's still kind of open out there. So you've got two duties for premises owners. One is to maintain the premises in a reasonably safe condition for foreseeable users. And the second is to correct or at least warn of or barricade off known dangerous conditions. So the first one doesn't require any notice, it just requires adequate maintenance of safe conditions. The second one, if it's an unreasonably dangerous condition, you have to prove that the owner had notice of it in order to hold them liable for it. So for example, if you've got a shopping mall and somebody slips on a spilled soda, they may not be able to hold them all responsible unless they can prove that it was there for a long enough period of time that it should have been caught by reasonable maintenance. Okay. Defamation. We don't see too much of that anymore either. It was big a few years ago, but kind of dropped off. And part of that is because with the internet and Facebook and YouTube and Plaxo and Twitter and all that stuff, everybody's public. There's almost no privacy. And yeah, you can limit the people who can access your stuff on Facebook, but you limit it to what, 138 people, close family friends? So there's not much defamation and slander. Libel and slander, one of them is oral and one of them is written, and it's just accusing someone falsely of moral turpitude or criminal conduct or something that is damaging to them in their personal life or their profession. So if I accuse you of being a thief, if I don't have proof of that, if I didn't have proof of it when I said it, I can be held legally liable for you. Even if it doesn't cause you measurable money damages, I can be assessed $1 plus whatever punitive damages the jury or the judge feels is appropriate. So one of the things about defamation cases, libel and slander cases, is you don't have to prove money damages. If you prove that there was libel or slander, you can get punitive damages depending on what they want to award. Okay, malpractice. The most common kinds are medical, legal, and real estate. They're all professional, well, there's a fourth, construction, but we don't usually call it malpractice, we just call it defective construction or negligence. In medical malpractice, as I said, there are two legal theories. One is informed consent. If the doctor does not get informed consent and they get a bad result, they're going to be liable even if they did not reach the standard of care, even if they were not negligent. Because without informed consent, it's an unpermitted touching, and so the damage is strict liability. The second kind of liability for medical malpractice is breach of the standard of care. If they did not exercise the care that a reasonably prudent specialist of their specialty would have exercised under similar circumstances, they can be held liable. But they will only be held liable if their breach of the standard of care is proven to have caused actual harm, some injury or some damage to that person. In the Tripler case, for example, they administered the wrong stuff to the kid and it caused serious brain damage. They administered CO2, I think, instead of oxygen. So that's a no-brainer. If you do a surgery and you leave the scalpel in the person, that's a no-brainer. It's pretty easy to prove. I mediated a case in which the first negligence by the hospital and the doctors was there was a tumor about the size of the top joint of your thumb, and it showed up pretty clearly on the films, X-ray, CT, MRI, and they missed it. And missing that is below the standard of care. And months later, they finally did repeat films and said, oh yeah, now we see it. So then they did the surgery. And after the surgery, the guy complained, oh, but I still have all this pain and all this really terrible feeling down in my lower abdomen. And so they did some more films, and they said, oh, gee, we left something inside. Not a sponge, not one of these little gauze pens, a towel. I mean, not full-size beach towel, but, you know, a surgical area towel. It's like a hand towel or something. But, so they went in to get the towel out, but because they let so much time go by between the first surgery and finally listening to the guy and taking another set of films, the towel had begun to adhere to the bowel. So when they took the towel out, it tore several pieces of bowel, and they had to take out 25 centimeters. That's 10 inches of bowel. Hey, why did that make a difference to this cancer patient? Because without that bowel section, you can't do what's called anathematizing the bowel to get around the colon cancer. So that person was an outside bag person, colostomy bag person for the rest of their life. They were young, they had a very attractive young wife, they had young children. This was a big general damages case. That's kind of an extreme example of medical malpractice, but it is true that in this country, there is a very, very high percentage of people who are the victims of medical malpractice. Most of it does not get discovered, or gets discovered so late that the people don't bring a suit for it. The rule in tort cases is usually, and motor vehicle is separate, we'll get to that in a minute, but in most tort cases you have to file your lawsuit within 2 years after the negligence happens. However, in a medical malpractice case, if the patient doesn't know about it, if that towel or that sponge is in there and they don't know what's causing the problem and it doesn't get discovered for another year, the 2-year time limit doesn't begin to run until the patient discovers the harm and the negligence and the connection between them. So we have the discovery rule. Where that rule becomes particularly important is we've all heard about cases where kids were abused by Catholic priests and others, stuff like that. What happens many times in the kids is, in order to grow up anything near mentally intact or healthy, they closet that. And they're literally not consciously aware of it. The emotional faculties bury it so that it does not impede their ability to grow up and function as a person, or it doesn't impede it a lot. If something happens later to bring it to their attention that they've undergone this experience and it causes them mental or emotional breakdown or harm, even if it happened 10 or 15 years ago, they can sue within 10 years after they discover the connection between that molestation or sexual abuse or rape or whatever it was and the harm that's been caused to them. And some of those cases are pending in this state right now. There are a bunch of cases where youth correctional facility guards raped minor female inmates. And although those cases happened years ago, those girls, when they were younger, were threatened, don't say anything, don't tell anybody, and they just buried it, never thought about it again. And when one of the cases went to trial 2 years ago and an investigation was done, a bunch of the other girls that were sexually assaulted were discovered, and in that process, they also made the connection between what had happened to them and some of the effects on their life. And they got treatment and they're in. So their cases are now about to come to trial. The state is, of course, saying, hey, you have 2 years, they knew about when it happened, done. The psychiatrists are saying, no, it's not that simple. particularly in abused minor cases, the psyche will